Hello, hello. The our governing board members from Bangladesh,
Thank you.
Judge Rahul Amin, very warm welcome. The resource speaker, Mr. Sobash Khan, and the participants joining us from different locations. Very good afternoon.
Good afternoon.
First of all, I would like to extend my warm welcome, especially to our governing board member from Bangladesh.
Thank you.
And also a special welcome to our resource speaker, Mr. Sobash Khan. And thank you very much for agreeing to work with us, especially in organizing this webinar today. One of the mandates of SARCO is to promote the growth and functioning of arbitral institutions in the member states. And pursuant to this mandate, year after year, we are organizing various webinars, seminars, workshops, and lately we are trying to focus on imparting specific or tailor-made training programs. So today's webinar is part of this series. And if you look at the program agenda, I think today's webinar will explore the issue of, or rather the topic of mediation as a precursor to arbitration. I think it's a very interesting topic and very developing area. And I hope the participant will take maximum advantage out of this webinar. And as my colleague mentioned earlier, this webinar is intended to be interactive. I would like to urge the participant to feel free, ask questions, and engage with our resource speaker. Try to get as much as possible from him when he makes himself available for us today. And I think I should give more time for the resource speaker to speak on the very interesting topic. With this remark, I would like to wish all the participants a very fruitful, engaging, and successful webinar. Thank you, everyone.
Thank you, sir. Our main thematic session for today is an overview of mediation in Pakistan, especially focusing on promoting alternate dispute resolution practices. To deliver on this, we have with us Barrister Zopash Khan. I'll just take a few moments to introduce him. Barrister Zopash Khan is a lawyer, mediator, and a social impact leader with over a decade of experience in dispute resolution, legal practice, and institutional development. He is among the 90 accredited mediators in Pakistan, officially gazetted and notified by the Ministry of Law and Justice. He currently serves as a co-chair of the Society of Mediators, Pakistan Chapter UK, chair of the International Dispute Resolution Institute, and partner at Pasha's Associate and Consultants. Alongside his professional practice, Barrister Khan is president of Help to Smile, a non-profit organization dedicated to access to justice and social inclusion. He has played a leading role in promoting ADR in Pakistan, designing awareness programs, and promoting international collaborations with mediation arbitration centers worldwide. He holds extensive experience in advising public and private sector clients, contributing to law reform initiatives, and building platforms for youth and women empowerment through legal innovation. His work stands at the intersection of law, mediation, and social change, where he continues to advance dialogue, access, and justice for all. Barrister Zopash, many thanks for joining us today, and we'd now like to invite you to deliver the lecture.
Thank you so much, Saqib, and thank you so much for being me. As Saqib has already introduced me, so today the topic which we are going to discuss is the precursor of the arbitration, promotion, and sustainable culture of ADR in Pakistan. So first of all, I would like to draw some attention about the alternate dispute resolution. That what is the alternate dispute resolution, and then we will go to the deeper appreciations of the things. So when the conflict between two parties come up, so from there the dispute is originated, and then we can move forward on the dispute. So there are the ways which we can opt for is the courts, and then there is an alternate of that dispute, how to resolve that. So in that, and why there is a need of a dispute resolution. So because of the backlog of cases in Pakistan is over 2.3 million pending cases, and alongside the mediation and arbitration mechanisms are effective and cost effective and relationship preserving alternatives. The ADR contributes to the social harmony and the productivity by promoting a quicker and fair resolution. So coming to the next part of the alternate dispute resolution, it includes the negotiation, mediation, conciliation, and arbitration. So when you are going for the negotiation is the direct dialogue between the two parties when they have some sort of dispute. Then we go for the mediation. Mediation is the facilitating dialogue with the neutral third party. Then the conciliation, a slightly more adverse role than the neutral, and arbitration, which is a private adjudication leading to a binding award, and then a formal litigation, court-based adjudication. So what is the basic difference between the mediation and arbitration? So mediation is a facilitative, voluntarily confidential, and non-binding. So arbitration is adjudicative, binding, and formal process. So in the mediation is a voluntary and confidential process, which includes the process led by a neutral, whereas you can see the arbitration, which is the adjudicator who is deciding the matter. So now when we move forward for the mediation, so what is the basic concept of mediation? That mediation is the facilitative process when the two parties are in the conflict, so they can opt for, before going to the arbitration, they can opt a mediation process. So how that mediation process is workable? So which in Pakistan, there is an ADR Act 2017, which empowers the courts to refer the cases, and even the parties under the Section 10 of the Mediation Arbitration Act. Mediation Act. It says that the parties can go to the mediation center, they can go directly to the mediation, or if they are in any sort of litigation, so they can go in mediation, where they can appoint a neutral under the Section 3 of the Alternate Dispute Resolution Act 2017. So the neutral, who is a duly accredited mediator, can do a mediation between the parties. So now this is an informal process where you have to trust in yourself. It is the same time-saving process. It's a cost-effective process. It preserves the relationship. You have the win-win situation at the end. It will be the resolving the disputes before you can begin for any litigation or arbitration. So going forward, so mediation clause in the contracts, why it is essential? What is the impact of that mediation clause in the contract? Because when we are looking for any contract where there is no mediation or settlement or dispute resolution clause, so the problem which we are facing in the system was that whenever there is a dispute, the people have to opt for the litigation. But the basic fundamental part of the contract is the mediation and dispute resolution clause, because an arbitration clause itself is an arbitration contract. So the first and the foremost is the cooling off period. When you go and opt for the mediation, it will give you 30 to 60 days in the act that you have to proceed with the mediation and conclude it. So the parties, when they are in a dispute, at the very outset, they are very in a heat up way. And then later on, then they were in the mediation, so they will cool down and they will exhaust that time. And then they can move forward for the arbitration. So in the mediation, when the parties come up, so there are, I would like to guide a small process of the mediation. When the parties opt for the mediation, so they would just simply reach to the mediator directly, or they can file an application in the mediation centers, or they can opt in their cases where the case is pending before the court, so they can opt from there that we are willing to refer that case to the mediation. So how this process runs, the case coming to the mediation center, there is an nominated registrar who can send the notices to the parties, call up, he will ensure about agreement to settle, agreement to negotiate, and the agreement to resolve that matter. So then they will be called for that. After that, there will be two kind of sessions. One is the private session and one is the caucus. I think Barrister Sultan has opened his mic, so the kids are talking. So when the mediation process is started, so the mediator will make the ground rules at the very outset of the mediation that this is a voluntary process. There is a win-win situation. You have to negotiate and come to the conclusion. And this is your decision which you have to opt. And then it is a very effective and a very cost-effective and the time-effective process in which both the parties have to decide for their own interests. And the role of mediator is to facilitate, to realize that how they can make their time effective and fruitful. So in that process, ultimately, both the parties, if they are going to be settling the matter, so they will go for the settlement agreement, and both the parties will sign the settlement agreement, or mediator will sign the agreement, and then they will make it as a decree of court, which is binding on them, on the both parties. So now coming to the next slide of my presentation, because I'm not sharing the screen with the participants, so, or I can share it with the Saqib, so he can share with the rest of the participants. So the global best practices are...
Sorry, Barrister Zopash, if you want, I can give you access and you can share it on the screen if you'd like that.
Yeah, for sure, if it's possible.
Yeah.
So
yeah, I've shared access, so you can share the screen. I think that would be better.
Okay, that's fine. Okay, I will continue. So the global best practices, what are they and how they are working? So there is a Singapore Convention on the Mediation. It was signed in 2019. Then as UK Civil Procedure Rules encouraging ADR and UAE and Qatar linked mediation arbitration centers. So these are the basic models. Then the UNICEF model of 2002, which is the basic a sense of the mediation, how they will work. So I can give a brief introduction about that. What are the available resources we have in Pakistan? So we have for the alternate dispute resolution, there is Arbitration Act 1940. CPC has amendment of 2021 where we can use the, and then there is a Punjab ADR Act 2019, KP ADR Act, ADR 2017, Islamabad. Then there are institutes which are working on the mediation, like OR Center. It's International Dispute Resolution Institute, which is duly notified by the Ministry of Law and Justice. And then there are court annexed mediation centers. And then there is the integrated system of family courts and the commercial courts, which are focused on the working on the mediation, and the court annexed mediation center, which are referring the cases to the mediation center, or they are doing it in their own capacity. So what challenges which we are facing to execute this mediation ecosystem in Pakistan is the first and the foremost is the lack of awareness. Sorry. So the lack of awareness between the stakeholders, and the stakeholders in the mediation process are the lawyers, the judges, and then the basic stakeholder is the party itself. So there is no awareness of the mediation, and the trained mediators are not available for us. Then secondly, we have a very overcrowded legislation, but the enforcement of that legislation is very low. So people and the lawyers and the litigants are reluctant to adopt the change. So which is very much challenging for us to cope up with that. People are not willing to opt the mediation process because they have already paid a lot of fees to their lawyers to conduct the cases, and they are willing, because in our culture, it's like we are willing to keep the dispute all the time. So if the resolution is there, so they will, then there is no winning situation for them. So what is the basic roles of the institution, like the International Dispute Resolution Institute or Society of Mediators? They are doing the training, certifications, and the initiatives for the awareness. We are reaching out to the schools, colleges, bar councils, bar association. Then we have reached out to the universities, the judiciary ministries, and the ADR centers which are working on that. So mediation arbitration med-arb model, how it works. This is a hybrid model combining mediation and arbitration, ensuring efficiency and continuity, safeguard needs against biasness. So the Civil Court Procedure Code allows the court to refer the disputes to the mediation center. The Commercial Court Act encourages ADR in the commercial litigation. Family Court Act and Small Claims Ordinance 2002 embedded ADR in specialized jurisdictions. So promoting a sustainable ADR culture, it will be integrate the ADR in legal education, court referral, mediation programs, public and professional awareness campaigns, and mediation clinics. So, so the benefits of the mediation first approach are the quicker resolution of the problems. So it will reduce the court backlog, improve the business confidence, and enhance social harmony. Then we are moving to the integrity in ADR in policy. National ADR policy, we need to develop that, and we have to work on that, because when there is a strong policy for the alternate dispute resolution, because in the international best practices, UK has made mandatory mediation so that you cannot file any claim to the courts. Rather, if you are not opting for the mediation, you have to pay the cost. So we have to bring the model ADR centers at the district level, integration with the family and small courts claims. So this will be enhancing the willingness of the people to come up for the mediation. Then role of lawyers, how the shift from the adversarial and collaborative approach will be changed, and how the practice, as before that when we have started the practice, it was only two practices that either you have to go for the civil litigation or for the criminal litigation. So there are two aspects. But now the fields are diversifying and there are so many avenues for the practice. So if any of the lawyer who is willing to opt his career in the alternate dispute resolution, so he has to develop the mediation advocacy skills and a basic trainings on the ADR for the mediation and arbitration. So it is a very emerging field which is coming up. And the future is in the mediation and arbitration, because in the global best practices and for the Belt and Road BNR of the CPAC in the Central Asian countries, we have to focus on the mediation or arbitrations, because they are not willing to work with the long and tedious litigation, which is going for the decades and decades and disputes and are not going to be covered up. So the call of action at the time is that to strengthen the institutional collaboration, like or judiciary has to take some steps, or institution of the legal fraternity, bar councils have to step forward, and then we have to encourage our business segments like Chamber of Commerce's to come up and hold the hands to encourage the better environment for the business community to run the businesses in an effective and efficient way. And we have to encourage very essentially the mediation clauses in the contracts to whenever the dispute comes up. So we have a mediation clause in our contracts, and then the arbitration clause, and then there is if there is no your dispute is not resolved, then you can go to the court. So my closing remarks are that replace the confrontation with the communication, litigation with the resolution. So what I want to say is that the confrontation is always very much risky. So when you communicate, you have dialogue, you can go for the resolving the dispute. So litigation is not the resolution of the dispute. So if you want to resolve the dispute, you have to sit, relax, and decide your future in your better way. So I hope that I have covered most of the aspects of the mediation and arbitration. So if the floor is open, if anyone has any questions, so we can discuss that.
Thank you, Versal. Thank you for the very overview of the mediation in Pakistan. I had a few questions actually regarding the way you explained everything. We understand that mediation is more common in, say, family disputes. Do we see any change or any preference in commercial disputes now of mediation?
Yes, as far as before that, cases were referred from the family courts and family mediation was very effective. But now the commercial mediation, which is the business community and the Chamber of Commerce's and the international best practices, they are opting for the commercial mediations. And yes, of course, we are working on the commercial mediation nowadays, and this is a very effective tool because the businessman is always willing to make his business running. And then when there is a dispute, so it will be a hurdle in his business running. So now the international best practices are focused on the commercial mediations. And now we have already signed the MOUs with Azerbaijan, Uzbekistan, Central Asian countries, China, Hong Kong, United Kingdom, USA. So these all are the major countries and the stakeholders which are focused on the international commercial mediation. So yes, they are focused, and this is very effective for this.
Thank you.
for the resolution.
So I understand that we have signed the Singapore Convention on International Mediation and its enforcement, similar to the New York Convention, basically, which is on arbitration enforcement. What kind of challenges do we face in mediation enforcement? Enforcement of any settlement which is done through mediation. What kind of challenges, being in practice, we have faced?
Actually, I would like to tell you one story about this a practical example. As there are two, because this system is new, so when the new cases were referred from the court, so there was a understanding for the parties that whatever mediator will decide, he will give that decision to the court, and that will be the binding for us. So once the parties have approached directly to our center and I have mediated that case, so I submitted an application under Section 10(4) of the ADR Act 2017. It says that if parties are going to settle the dispute out of court directly with the mediation, and they can come up to the court and they can make their agreement to the final settlement decree. So I submitted that application to the court, and the court was very astonished that what sort of this case is that we don't know about this case. I said it's not a case, it's a mediation settlement agreement, and you have to just notice the parties, record their statement, and even that is not necessary, but you have to pass a decree on this settlement agreement. So court was very much shocked for that. Then he said that, okay, I will... First, they were reluctant to institute that case, and later on, then he instituted that case. But he said that I will look up for this and I will discuss with my seniors and high ups. So if I get something, then I will do it. Then I will assist the court that there is a section, this is a law, and this is the process. So you have to do. And it took me 1 month to execute that settlement. Even the mediation took concluded in 1 day. But the settlement award was done in 1 month, because the challenge which I was like to highlight here is the lack of awareness, that the courts and the system is not aware about that how this process is going to work.
Yeah.
So then after that, I have organized a training for the judges to sensitize them that how this mediation process works and how this settlement agreements are made a rule of code. So now I'm not facing such challenges, but it was the first story which happened with me.
Interesting. So what mediation took 1 day, but enforcement took 30 days.
Yeah.
Anyways, so Mr. Zupash, one more thing maybe you could enlighten upon. So you are an accredited mediator, one of the accredited mediators in Pakistan. What is the process of, say, being an accredited mediator in Pakistan? So for people who might be interested in this field, what's that process for that?
So, sir, first of all, to become an accredited mediator, you need to go through from the 40 hours accredited mediation training, which is globally, there is a standard of International Mediation Institute, and the Society of Mediators is regulating that. So you have to do your 40 hours accredited mediation training. After your training, there is an assessment. When you pass your assessment, you will be notified as an accredited mediator. Then in Pakistan, you have to come up for another challenge, which is our Ministry of Law and Justice has an ADR section. So on the website, you will find a form A and B. I think it's a form A, which you have to fill up with your certification, your experience, and then you have to affiliate with one of the center, which is duly notified by the ministry. So you have to affiliate yourself with that. Then you have to follow the rules, code of conduct, fee structure, which is already published on the ministry website and the law mediation center website, because this process is very clear and open to all. So there is no hidden charges and all that. And there is then when you will follow the whole process, that you have the code of conduct, you have the fee structure, you have the ethics, you have the rules of the mediation, and all those are under the umbrella of IMI rules. So after that, you have to submit that application in Ministry of Law and Justice. So there are three committee members of that: the Secretary of Ministry of Law and Justice, High Court Registrar, and the section officer itself. So they will decide if your application is fit for that. So then they will do a gazette notification, and then you will become a
Long process.
gazetted. Yeah,
Long process. But I
even in the globally, it's not that much hard, because when I was in London, so
okay. So I'm assuming that
so
this is just a requirement as per Pakistan, but you can still do ad hoc mediations, right? I mean, just as a
exactly.
normal.
This is what I was adding in, that when I was in London and I did my mediation certification from the Society of Mediator London. So I have avenues to work in 56 Commonwealth countries. And my certification is workable in rest of the world, but still Pakistan has some different rules. So I
Go
have
through a
to
different.
follow the process too.
But is that Islamabad specific, or is that applied to the whole of Pakistan? The rules accreditation.
No, the mediation rules are, as we are working in ADR Act, under the ADR Act for the particularly Islamabad. So
Okay.
it is, these are the rules for the Islamabad, but for the rest of the Pakistan, you have to register yourself from the Ministry of Law and Justice, because without the gazetted notification, because all the acts are saying that there is a neutral who is duly notified by the Ministry of Law and Justice or by the High Courts. So you have to follow this process.
Okay. I think one last question, then we'll go to the question that we've been asked on chat. Would you say, I mean, given your experience of the enforcement of a settlement agreement, would you say that there's a huge requirement for training for judges, especially when it comes to mediation?
Actually, I think that the trainings for the judges, for the lawyers, and all the stakeholders is very much important, because when this system is coming up and this ecosystem is developing, so all the stakeholders should be known about it, how this process is going to work, what is the effects and what is the outcomes of the process. So it is essential, because awareness section is very much important for all the segments.
Okay, I think we'll now move to the question that's been asked in chat. So I'll start with the first one, which was asked by Malik Nadeem. My question is, how can council embed mediation into overall arbitration strategy while preserving privilege, confidentiality, and tactical strength? So I think the question is how to do MED-R, basically. How does the MED-R process work?
So I have already described this thing, but when council working on the MED-R process, so whenever you are going to opt for any case and going into the starting your litigation, before that you have to give a mediation notice at the first hand. If you go for the mediation, if it fails, then you can go for the arbitration. And after that, if both the things are failed or they are not in your favor, then you can go for your litigation. So the foremost thing is that you have to put the mediation clause and arbitration clause in your contracts. After that, when the disputes come up, so you can refer to your mediation and arbitration clause, and then you can proceed with your matter.
Okay, so step by step, basically, yeah. No, I think the question basically just talked about how to ensure that mediation can be part of this. I mean, when people talk about ADR, not just in Pakistan, I think overall they always focus more on arbitration being the the end all of everything. But of course, people then in the process unfortunately ignore mediation, and mediation that can play a very important role. So I think we understand the point that it can be step by step. So just going to the second question, which Pakistan-specific reform would most accelerate mediation before arbitration? Legislation, court annex programs, institutional rules, accreditation, or cost incentive sanctions?
So these all are the very important components, because if you imposing, I will start from the last line. So if you impose the cost, so people will lack the trust on the system. Yes, we need more accredited mediators. So we have to expand because the notification last was done in 2023. And now we are sitting in 2025, so no further notifications was coming up for the mediators. So yes, we need more and more and more accredited mediators because we have 350,000 lawyers in Pakistan, but out of that, we are just a few, like 100 people right now, gazetted notified mediators. So we need to extend that program. Yeah, and then you are saying that yes, we need to. We already have a lot of legislation. We don't need more legislation, but we need to implement that, and we need the legal backing of that, the institutional enforcement. That yes, this mediation is the process. We should, as there is a mediation clause, and the mandatory mediation should be imposed on the all the litigants. Like anyone who is going to file the case, we have to go from the mediation. So that will be an effective and we can say that it will be an effective tool. So already we are following the international rules, and the institutional development are there, but we need to focus on all the components. Like there is no need of reforms. There is a need of awareness. There is the need of institutional backing. We already have the legislation. So we have to enhance the accredited mediators, train them not only to the judges, to the legal fraternity lawyers. I myself made more than 300 mediation advocates and like 60 accredited mediators in Islamabad Bar Council. So this is what I can contribute, but rest of the people have to contribute and their part to expand this ecosystem.
I think just part of this question, I'll maybe break down a little bit, like some subparts from the question. I understand there are already court-annexed mediation centers, right, in the major Islamabad High Court, I think, Sindh High Court, and maybe some other courts as well. But I'm not sure if there are any cost incentive sanctions. So basically, if a party unduly rejected mediation, would that result in any cost on the parties?
Actually, when there is if you follow the international best practices, yes, the costs are imposed on the parties who are not opting for the mediation before going to any dispute. But in Pakistan, if we file a frivolous case and we ruin his other party's life for 10 or 20 years, and ultimately the case is dismissed without cost. But in recent judgments by the Justice Babar Star, he has imposed huge costs on the lawyers and the parties for the frivolous litigations. And Justice Darjas has ensured this thing that if a party is not going for the mediation and they are reluctant to proceed with the litigation, so he has imposed the cost. So yes, this is a process under the CPC section 35 and 35A can be implemented in its letter and true spirit, so it can be effective tool.
Okay, thank you. In addition to that, legislation coordination programs. I think accreditation and cost incentives we already talked about. So I think, yeah, we can move to the next question. So beyond settlement, how should partial outcomes, narrowed issues, agreed facts, process agreements be recorded and carried into arbitration to save time and cost? So basically, if a settlement has not completely, materialized, and if a party is going from mediation to arbitration, how can that process then also be carried into the arbitration process?
So if we are going for a mediation and we have settled to some extent, like we agreed that A, B, C, and D clause are agreed, and this is the settlement. So when we make that mediation agreement as an court decree, so then there is an provision under the CPC for the execution of decree. Then if you exhaust the mediation, because mediation has its own act and the arbitration has its own act. So when you are doing a mediation and that the forum is exhausted and you have concluded the settlement, then you will go for the mediation mediation is done, you will go for the rule of court. That rule of court is an executable decree. If you are, you cannot save that process for the arbitration, that later on I will go for the arbitration. Yes, if you have opted for the mediation and there is an arbitration clause, then you can go, but there is no need of that. I haven't seen that thing in my experience, that any mediation settlement agreement has the mediation or arbitration clause further, because the mediation agreement is once for all the settlement. So it is a win-win situation. Parties are willing to do that. But if they are not doing, then there is a clause, execution of a decree. So you can execute that decree. You can go after the party and make that decree executable. So I hope this question is addressed in the proper way.
I think just a follow-up question to that. If, say, for example, a mediation fails, the parties went into mediation, but they couldn't come to a settlement. What does that ever prejudice the outcome of, say, a future arbitration? So would that non-settlement would result in bad arbitration then?
No, because this is mediation is very informal and confidential process and non-prejudice. So nothing goes out from that room. So if the mediation fails, yes, then they have the option to go for the arbitration. They can opt for the arbitration, and then the process of the arbitration will be done in free and fair manner, and nothing can be used against them, whatever happened in the mediation process.
Okay. I think that's great. Next question. Over the next 12 months, what concrete steps should institutions, bar associations, and in-house teams take, training panels, model clauses, to normalize mediation first practice? So, Mr. Zopash, in your experience with bar associations especially, what kind of would you say that steps are needed from, say, bar associations to further strengthen this practice?
I would like to tell you first what we have already done. So in a bar vocational course, which was in the light of the Supreme Court judgment for the betterment and the continued legal education of the legal fraternity. So the bar vocational course was introduced, and then the alternate dispute resolution subject was mandatory to taught to the students who are going to take the licenses. After that, we have taken very bold steps for the bar associations and the bar councils. We have, as I've already said that I personally trained 300 mediation advocates, mediators, and the awareness session for the ADR and all that. Yes, bar councils have to take bold steps for the awareness and the development of the lawyers, their capacity building, their professional development. So the trainings, seminars, and the conferences are the tool by which you can spread the awareness and they can make this system more sustainable.
Okay, and in addition to the bar associations, has there been any you can say preference from companies rather, to be to have some
for in-house and the companies? Yes, we have reached out more than number of businesses working in Islamabad and Pakistan, big companies and the small companies, through the Chamber of Commerce's, Federal Chamber of Commerce, and the provincial and then the district level Chamber of Commerce. Yes, we have done a lot of awareness sessions and mediation sessions with them. You have to reach out to all the businesses, because when there is an awareness about incorporating the mediation clause and arbitration clause in their contracts, because on the daily basis there are a million of contracts are going to be signed by every business, by either they're buying or they're selling, they're doing trading, or whatever they are doing, they are signing in contracts. So in contracts, when the mediation and arbitration clause are incorporated, so then if in later on the disputes come up, so those can be dealt with the mediation and arbitration. So that, yes, we are reaching out to a lot of businesses, a lot of the Chamber of Commerce's, to give the awareness sessions and bringing up the aptitude of the community towards the mediation and arbitration.
Okay, thank you. I think we'll go to the last question. What clause language or case management milestone should trigger mediation early enough to add value without becoming a box ticking exercise? So I think this talks more about conflict avoidance and how, mediation can be done at the right time instead of just doing it for the sake of, completing a formality.
So in contracts like large contracts, or you can say the small contracts, on every point you can go for the mediation. Yes, it is a very effective and efficient tool to avoid the conflict. So there is a risk management mechanism whenever you are doing a business. So you have to know about that what steps if I take, they will lead to a dispute. So before that, and this is the core responsibility of in-house counsels and the in-house teams which are working to avoid the conflicts. But if the conflict come up, so then that is the right time to send them a mediation notice, resolve your matter, rather than lingering on it and going for the long, lengthy litigation, and then you are not with having anything in your hand ultimately.
Okay, I think that's all the questions. I'll just invite Mr. Ruhul Amin from Bangladesh, sir. If you may have any questions or maybe any comments from a Bangladesh perspective. Ruhul, sir, are you with us?
Yes, thank you. And thank you for inviting me. Am I audible?
Yes, sir. Yes, sir.
Yes.
Yes, oh, thank you. First of all, I like to thank Mr. Joseph. Nicely elaborated the mediation process, ADR process in all respects, and especially what practice is being going on in Pakistan. I especially just a simple question: how many disputes, percentage of disputes are being resolved through mediation now in Pakistan? If it can be, there is any data?
So, Barrister Gopash,
Yes, sir.
you-
There is a data that can. Yes, there is a data, sir. It is a pilot process which is going in Islamabad. So the and total 400, and out of which the success rate of the mediation was like 63%. And
Nice.
I personally have mediated 70 cases out of
Oh, nice.
400.
Excellent.
Yeah.
Excellent. In another aspect, I would like to know, just we know that whether every lawsuit, in case of filing any civil suit especially, whether the mediation is mandatory provision, have you inserted in any mediation law?
Sir, actually, before that, it was not a mandatory provision for that, but now the courts have, under the mediation rules,
Okay.
they are bounding the parties. They will submit a mediation consent form
Okay.
before the court when they are filing the case. So, and on the first date of hearing, the court will ask both the parties that whether you are willing to go for the mediation, because there is a consent form you have already signed for the mediation, because now we are making them bound that they have a consent form of going for the mediation. So then after that institution, if courts think that this matter is a resolvable matter, so then they will refer that case to the mediation center, and then mediation center will do the process and all that, and then come back to the court.
Oh, I see. That is, before filing a mediation process, observation of mediation process or is not mandatory yet. Like Singapore, we see that in Singapore, if any person like to bring a family suit or civil dispute, in some cases, they must have the course of mediation. And the mediation center, when issued a certificate that mediation has failed, then only he can file a lawsuit.
Yes, sir, we are hoping for this, that it can be incorporated in our system as well. But still, unfortunately, we don't have this system.
Oh, okay,
Yes,
fine.
when I was working in UK, there is a mandatory mediation, and we have to follow the mediation first, and there should be a certificate that yes, mediation was failed. Then you can file the case.
Fine. I have last question.
Yes,
Since
sir.
we all are, especially Pakistan, Bangladesh, India, same law background and colonial system, British law we have introduced. In respect of lawyers, whether they embraced it or the accepted or welcomed the mediation process by mediation systems in your country, or they opposing, or they feel that if mediation process is accelerated, then their business or their chamber work will be hampered.
Yes, sir. There is when we started this process of mediation and the arbitration trainings. So yes, there are old school and the people following that purely litigation thing. They think that this will, like people say that AI is now obsoleting us from the system, because there is no need of lawyer or there is no need of judge. So same, the mediation process, lawyers are worried about their business, that if this is started, so our business will be finished. But after doing the mediation training and the mediation advocacy, they come to know that if they will refer the case to mediation and they resolve that mediation case through mediation, so yes, they are getting more cases. Even the litigants are thinking that this ADR will us that spark, because it is going to resolve our dispute.